You're very young, and the episode and how you acted here in court and once you got to jail that day that's just a very um immature way
Yes, ma'am.
of handling things. And it also, of course, gives me a lot of concern on whether or not I should give you a probation. So I'm glad to hear that. Anything, Mr. Smith, before I sentence?
Judge.
All right, then, Mr. Rayleigh, I'm going to give you this opportunity today. I'm going to find that you previously entered your plea of guilty freely and voluntarily. And this is cause number 25 DCCR 1482. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the JCDI program, which is an outpatient treatment program to make sure you are clean and have all the tools to stay clean, as well as any type of recommended treatment for any mental health issues that might be going on as well. Okay, so you're required to do those things, whether you feel like you need them or not. It's all just so that I want you to be successful in this to be a turning point. You change your life. Okay.
Yes, ma'am.
This is a great opportunity. You're young, you don't have a felony conviction on your record, and if you successfully complete this probation, at the end, the case is dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you don't follow through with treatment, you test positive for drugs, you don't go to appointments, whatever it is, you're going to be back in here. You could be convicted of the offense, so you'd be a convicted felon and go to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get out today. Probation will talk to you before you leave the courtroom, but the first thing you do is make sure you follow their instructions, go straight to probation. Remind me, Brandon Louie? It was Mr. Smith? Okay. Okay. See, this is Mr. Nichols on Corbin Rayleigh. Good morning.
Good morning.
You're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh was previously in court in cause number 25 DCCR 1482, entered a plea of guilty to the state jail felony offense of engaging in organized criminal activity. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Yes, sir.
Any additions or corrections?
No, Your Honor, not from this time. Comments?
Go ahead.
Just that I want to tell the court that this is a completely different young man than I saw in court previously and at my office or over the phone. He's polite. He understands the proceedings that are going on. He understands that I think the comments that he made to the probation department were before or immediately after going to jail. He understands now that what he did is a felony. He accepts responsibility for it. In talking with him this morning, he's like I said, he's a completely changed individual. I think he's going to do well on probation if he can keep this up.
That's good to hear, Mr. Rayleigh. You can get everything started and do well.
Yes, ma'am.
Okay. Good luck to you. Thank you, Mr. Rojas. Ms. Holmes, you've got Frederick, oh wait, let's do Martin Fonseca Cardenas.
Yes.
Martin Cardenas. Morning. We're going on 3.
His two
There's also
TRPs.
dismissed.
Oh, 2 of them are MTRPs.
Yes.
Please, the 2 MTRPs would be great.
Yes.
Which one are you printing him? Three years deferred? I didn't. 3 years deferred.
You didn't say.
Okay,
Say it.
let's see. It's on. Which one are you printing?
The 19. I 24.
Okay. Just to say, that's okay. I'll print this. All right, and Ms. Burge was previously sworn in to translate for us. Ms. Holmes, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Sir, are you Martin Fonseca Cardenas?
Yes. Yes.
Mr. Fonseca Cardenas, in cause number 26, DCCR 0619, you're charged with the third-degree felony of harassment of a public servant from March 19th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah.
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Two.
Yes.
In that case, I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit 1. Before you signed these, did you go over them with Ms. Holmes and the interpreter?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made, that you'll be waiving any right to appeal?
Okay.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Fonseca Cardenas is not competent?
No, Your Honor.
All right, sir, in cause number 26, 0619, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, and understand the nature and the consequences of your plea. And also, before I go forward, do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Okay.
Yes.
Then at this time, I'm going to find sufficient evidence to find you guilty and find you guilty of harassment of a public servant, sentence you in accordance with your agreement to a term of 4 years in prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then we have, go ahead.
No van a incluir los 6 meses.
He's asking if the 6 months are gonna be included. Yeah, he's been in custody since February.
Yes. So then I have cause number 23, 1824 and 23, 1825 in. Should they both be first amended, or is there one that's?
They're both, yeah, but they're both first amendment.
Pull the right one up?
Yeah.
They're both first.
Okay, let me print out the correct one. In 1824, I have a first amended motion to revoke your probation. Shows that you were placed on probation February 6th of 2024 for evading arrest or detention with the use of a vehicle. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yeah.
I believe,
Yeah.
that may be a typo, Judge. It looks like one of my files showed that he pled for 10 years probated for 5, not 10 probated for 10.
It's 10/10? Okay. And then in cause number 1825, I also have a first amended motion to revoke your community supervision. Shows that you were placed on probation February 6th of 2024 for the state jail felony of unauthorized use of a motor vehicle. And that was a 2-year term in state jail that was probated for 5 years. Is that correct?
Yes.
Each of these motions allege that you violated your probation. Would the state mind narrowing down since there's an agreement?
Yes, Judge.
Which one's the offense we just took care
I
of?
think the March 19th one, so it's 5.
It's gonna be on 824. It's gonna be 5.
Okay, the March 19th date on both of them.
Yes, Judge.
All right, sir, in 1824, count 5 in that motion alleges that you violated your probation by committing that new offense of harassment of a public servant, March 19th of 2026, that we just talked about in the other case. And is that true or not true?
Yes.
True or not true?
¿Cierto o no cierto?
Sí,
Tiene que decir cierto o no cierto.
cierto.
True.
Thank you. And then in 1825, the state has elected to proceed on count 7.
Y vamos a hacerlo con el número 5.
It also alleges that you violated your probation by committing the new offense of harassment of a public servant, March 19th of 2026.
Marzo del 2026.
And is that true or not true?
No cierto.
Yes.
¿Cierto o no cierto?
Cierto.
True.
Did you enter your plea of true to each of those counts freely and voluntarily?
Voluntariamente. Yes.
In both of those cases, I also have here on the tablet some documents that have your signature on them. Did you also go over these with Ms. Holmes and the interpreter?
Yes.
Do you fully understand those also?
Yes.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. Any is there a question?
He's asking if you can send him to a different prison.
No,
Dice que no.
it's not up to me.
Dice no es la decisión mía.
It's up to the prison authorities.
La decisión de los oficiales en la prisión.
Okay. So in cause number 23, DCCR 1824, I'm going to find that you entered your plea of true to count 5 freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation. And at this time, revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 1825, find count 7 true. Find that you sufficient evidence to revoke your probation. And at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These three cases will run concurrently, which means together at the same time. I'm going to sign a dismissal as part of this agreement in cause number 26 DCCR 0620. And then the state will get dismissals in your two misdemeanor cases, 26 1097 and 1098. I'm handing you in these cases the certifications that shows these were agreements that I followed, so you waived your right to appeal. I also handed you an admonishment in Spanish regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about those laws, you can talk to Ms. Holmes. Okay, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Burge.
Thank you.
Thank you, Judge. Thank you.
Thank you, sir. Douglas Miles.
He's not here. They didn't bring him. He was here on a bench warrant. When I did the docket, he wasn't in custody, so they didn't bring him. So
Okay.
I'll just read that to him.
Okay, all right. And then Bryson Parkerson.
Yes, you may not. You.
Just me.
That's a bond.
Yes, ma'am. Frederick Bruno.
Bruno.
Like this has been a long morning.
Week this morning.
It has been a long week in one day, seems like.
Yeah. Fred.
All right, sir, you're Frederick Bruno. And this is cause number 20-35302. Mr. Bruno is on probation for the third-degree felony offense of assault on a family member by impeding breath or circulation, and that probation was from November 30th of 2020. It was a 10-year term in prison that was probated for 10 years. There's been a first amended motion to revoke community supervision filed. Allegations allege an evading arrest or detention with the use of a vehicle from April of 2026, possession of a controlled substance from April of 2026, failure to report arrest from that April 26, possession of a drug, synthetic marijuana on that same date, behind in court assessed fees. Then it goes on that there was another offense of possession of a controlled substance, July 24th of 2026, two on that same date, possession of a controlled substance. Also a failure to report to probation, April 28th, May 28th, and June 17th of 2026. Ms. Holmes has filed a motion asking that I set a bond in Mr. Bruno's case. It is a straight probation. Ms. Holmes, do you wish to call your client as a witness?
Yes, Your Honor.
Sir, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Ms. Holmes, and be sure you speak up so I can hear you and the court reporter can hear you.
Could you state your name for the record?
Richard Sam Bruno.
Okay, and Mr. Bruno, how long have you been housed at the Jefferson County Jail?
Since 24th of last month.
Okay, so almost a month.
Mhm.
Okay, and since then you have not had a bond set in regards to your case. That's a motion to revoke probation, correct?
Correct.
Okay, now you've heard the judge go over the allegations in which they've stated you violated probation, correct? Okay. Are you asking that a bond be set while this motion is pending?
Yes,
And if the judge sets a bond, are you willing to abide by any conditions such as drug patch or GPS monitoring to ensure that there are no further violations or allegations?
yes.
If you were to be given a bond, where would you be residing?
4493 Harding Drive,
Okay, and is
Say it
that,
again.
4493 Harding Drive.
Go ahead, sorry.
yes, ma'am. And is that in Beaumont?
Yes,
Okay, and who lives at that address?
but
Okay, okay, and so you would be residing with your mother if you're able to be granted a bond. Okay.
Be sure you say yes or no.
Yes.
Thank you.
Okay, and is there anything additional that you would like the court to know?
man, I'm ashamed.
We'll get to, but just in regards to the bond, if you were granted a bond, will you abide by any conditions? You gotta say yes or no. Okay. Okay, I'll pass the lead, Sharon.
Mr. Smith, any questions of the witness? So I'm just going back. It looks like as part of Mr. Bruno's probation, he was placed on probation in 2020, but then there was some issues apparently in 2022 where he was continued on probation, but ordered to enter and successfully complete the safety program as part of probation. And it's like, I guess he did that. And then we're here with all of these allegations with regard to possession and some drug issues and things like that. I have taken judicial notice or am taking judicial notice of the court's file. It does include within my file with the administrative hearing this time, the probable cause affidavit with regard to the new possession offenses from this year in April. Anything else? Miss Holmes, you may go forward with argument.
Yeah, Sharon, I do understand, obviously, these are serious allegations that I've gone over with Mr. Bruno. We are asking that if a reasonable bond be set, so that he could try to get back on track. And obviously, because of the allegations, with substance issues, we know that it would be in his best interest if he is granted a bond, that it be monitored via drug patch or something to that nature, just to make sure that he stays on the right track. In addition to GPS monitoring, he says he will abide by that as well. If there's any fear of absconding, because we do know that that was an allegation as well.
Mr. Smith,
Judge state's opposed to a bond. He committed a new felony offense in April. We filed a motion in May. He got out of jail in April. Committed a new offense in July. We had to amend our motion that was already pending, and here we are again. I just don't feel like bond is appropriate for this defendant.
so it looks like there was I've got the timeline. There was an administrative hearing from April 21st, which had the allegations from the traffic stop from April 16th of this year, which resulted, it says, in a brief pursuit, and then after that, that was the defendant was found in possession of multiple baggies containing synthetic marijuana, charged with evading and possession on that date. He was released the 19th, so 3 days later. Then we get to the second, so a month and a half, 2 months later, a revoke for unadjudicated probation that was filed. There were pleas of not true that were entered, and this was reset for a sentencing hearing today. I have the updated pre-sentence report. It's my understanding, however, that you guys have now reached an agreement and that Ms. Magruder intends to change her pleas in that motion. Is that correct?
That's
All right, will she waive the formal reading of the motion?
Yeah, we'll wait.
So, Ms. Magruder, we already went through this motion, but because there's going to be a change of plea to some of those allegations, I'm going to go back through it with you, okay? So, I have a motion to revoke your unadjudicated probation. It shows you were placed on probation January 29th of 2018 for the second-degree felony offense of sexual assault of a child, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department May 23rd and June 2nd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you did not submit to alcohol or drug screening June 2nd, May 28th, and May 19th of 2025. And is that true or not true? I'm sorry.
True.
Thank you. Count 4 alleges you're behind in your court assessed fees. Is that true or not true?
True.
And then count 5 alleges that you did not enter and successfully complete the Jefferson County Drug Intervention Program, the JCDI program. Is that true or not true?
True.
All right, did you enter your pleas of true now to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And because they're actually true.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them with your attorneys that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Bynum?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence Ms. Magruder's not competent?
No.
All right, Ms. Magruder, then at this time, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you in accordance with your agreement to a term of 9 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also have handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Bynum. And we went over way back when you first got this probation, also the sex offender registration. You've already signed that and understand that that's part of this case as well.
Yes.
Okay, good luck to you, ma'am. Thank you all for working it out. Thank you for being here, Ms. Becker.
It's just brief. It's not.
Okay.
I said, I wrote it 10/5/25. I said, I want to first start off by saying I thank you for giving me a chance and seeing in me what I can't see in myself. I remember what you told me the last time I came to court, and my mind or heart isn't set on going home today. But the Lord just placed me in my heart to tell you thank you for being you. I will do my best to make sure I'm being a better person while in jail. I just want to thank you, y'all.
Thank you for that. Good luck to you. I really do wish you the best.
Thank you.
Okay.
The subpoena deuce is taken to the hospital. It's name records or whatever, and for whatever reason, they weren't delivered the last time we sent subpoenas out. They were delivered this time.
All right. Well, since you got them, I mean, it was over a week and a half out. So I'm going to number the case.
Okay.
Has there been any change as far as negotiations or anything like that that I need to take into consideration?
Okay.
All right. So I'll number the cases this afternoon. I mean, today after docket, you
Okay.
guys will know the trial order this afternoon.
Okay,
All
thank
right.
you.
We'll see you next week. Patient 1, Mac. Ms. Shipley. Good morning.
And you don't look like Mr. Coleman. I'm joking.
And you don't look like Mr. Hannah. We've got all the wrong people
It's
here
a
this
good
morning.
day, isn't it?
Yeah.
Well, yes, we'll get there. At least help most of these people.
Good morning, sir. Are you Tajuan Mack?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
We will.
Yeah. I'm getting there. No, this has just been going on a long time, so I've got lots of pages to scroll through to get all the way back to the indictment. There it is. Mr. Mack, in cause number 24, DCCR 1046, you're charged with the state jail felony offense of criminally negligent homicide from March 10th of 2024. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then, let's see, 85, in cause number 26, DCCR 0085. Sorry. You're charged with a third-degree felony offense of bail jumping and failure to appear from December 15th of 2025. And how do you plead to that charge? And again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In both of those cases, I have here on the tablet and some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Shipley?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Mack is not competent?
There is no evidence.
All right, Mr. Mack, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 24, DCCR 1046, find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0085, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of bail jumping and failure to appear. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. And I'm going to sign a dismissal as part of this agreement, and cause number 26, DCCR 0086. If you'll please print 1046 for me. I sent it to you. Apparently it didn't print. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you did waive your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Jipley. All right. Good luck to you, sir. Thank you, ma'am.
Thank you. Yeah. See you on the other side.
Yes, ma'am.
Ma'am. Mhm. Yeah, yeah. Uh-huh. I thought we already, it's set for trial. For next week, I don't know why they're trying to do it anyway.
Anyway.
Ms. Prazzo on Traylon Hill. Yeah, it's free trial, it's set for trial next week. Morning.
I just realized two different shoes.
Do you? That's awesome. That's fun.
Now are they both the right or the left or they're just different? They're right and left. Don't know. I've done that. Two lefts.
Yeah.
They're both black. If
That's
you wouldn't have
good.
pointed it out, nobody would know.
Traylon Hill.
Okay. Come from the other side.
Okay, I'll call it as soon as he gets back over here. Mr. Radford on Christopher Bushnell. Do we have him over here?
Yeah, Bush now?
Good morning. Good morning, you're Christopher Bushnell. And Mr. Bushnell is here. We've got cause numbers 25 DCCR 0112 and 0113, where there are motions to revoke Mr. Bushnell's probations in each of those cases. And then we've got 3 new indictments. We've got 26 DCCR 1222. Mr. Bushnell's charged with murder. 1223 charged with aggravated assault with a deadly weapon, and 1224 also charged with aggravated assault with a deadly weapon. And Mr. Radford, what is the announcement?
Judge, I have visited with Mr. Bushnell about his version of the events. I have just recently received an offer from Mr. Coleman. I'm waiting on the media.
Okay, so you're taking this one though, aren't you? Or is this gonna be?
No, Mr. Coleman's already worked it up, met with the family and per some instructions above my head. He's also gonna be involved. I told him, of course, I would assist. He's aware of the court's concerns about his going back and forth, so I will obviously stand in for whatever is needed.
Okay. All right, and I'll probably talk about that as well with them, because it's just gonna be, it's too hard to have him over there and trying to come back over here, especially on cases that need to get taken care of with a lot of information. So I'm gonna do a normal reset and to give you some time to get all that media and then go over it with Mr. Bushnell and we'll see where we get at the next court date.
Yes, ma'am.
All right, thank you. You can go back with the bailiff.
May I be excused?
Yes, sir.
I'll express that concern to if you want to go back upstairs.
Okay, thank you.
We have Mr. Gilman on, Judge.
Mr. Hill, come up, please. This is Mr. Nichols' case, is he?
Thank you for having me today. I want.
Hold on, don't talk yet. All right, are you Traylon Hill?
Yes, ma'am.
And this is cause numbers 24 DCCR 1500, 1614, 1615, and 0436. Mr. Hill's cases are set for trial with jury selection to begin next week. And what is the announcement?
We're ready for trial. State's ready.
All right, then
I
I'm
didn't wanna
going
go
to,
trial with it.
what?
I didn't want to go to trial with it.
Do you want to take a plea agreement?
I want to file some motion before I go to.
You don't get to file motions, Mr. Hill. Your attorney's taking care of all that. You don't get to, don't talk over me, Mr. Hill. We've been through this too many times. Your case is set for.
Talk to, I don't want to go to trial, because I don't have any evidence on my case. I want to
Okay.
get a release of discovery, dismissed because of delay, dismissed because it's still a complaint.
That's all denied, Mr. Hill. Go back with the bailiff. Your case will be going to trial probably next week.
That doesn't make any sense.
Go back with the
Why
bailiff.
you-
Always said she does, Mr.
Oh, damn. Why would you push me like that?
Damn.
one case for next week.
Thank you, Your Honor.
Mr. Parker, you got Malcolm Williams.
Yes, ma'am.
I didn't mix interview for continuing probation, so I just put continuing probation.
Say it again, I'm sorry.
I didn't know what to put on the motion to revoke because he's going to continue in
Oh,
probation.
okay.
Part of his plea deal says he's an ID. He's a transient. That's been his issues.
You can't be treated at mental talk without
An ID.
a valid idea of something.
Oh, shoot.
Good morning. Are you Malcolm Williams Jr.?
Yes, ma'am.
Give me just a second. My screen's now locked up. Will your client waive the formal reading of the
He
motion
will.
and the indictment?
Yes, sir.
If I can get to it, let's see here. Okay, here we go. Mr. Williams, in cause number 26 DCCR 1254, you're charged with the third-degree felony offense of failure to comply with sex offender registration requirements from June 2nd of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they've charged you with?
yes, ma'am.
In that case, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes,
Do you fully understand them?
yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So that looks like the agreement that you've reached is for a 4-year term in prison, but that would be probated. You'd be on probation for 4 years. You'd be required to follow all of the rules and conditions of probation, including getting an ID within 90 days of sentencing. That's the most important thing because you have to have your ID so that you can register. You understand that?
Yes, ma'am. I got a question. It's not, I'm just trying to see how long, like, would it usually be to get an ID? Like, let's say
You can get one they can give you
Yeah,
a
you
temporary
can-
one until when you go there, they'll give it to you.
You'll get a piece of paper that day and then they'll mail you the actual plastic copy later. So as soon as you go in, and you probably will need
Cause
the other.
I'm playing, let's say, because I might be, if whatever I get out, I might be walking this day and I'm planning to go tomorrow, the next day.
Right,
Every
so
time.
you're gonna have plenty of time and probation will help you. So when you get out of custody and you start your probation, you're gonna go, the first thing you're gonna do is go to the probation office.
Yes, ma'am.
You can ask them all those questions and they will help you with everything. Okay, because you're probably gonna need some other information. You're gonna need to get a birth certificate or something else too before you go get that. So they'll help you get everything you need. Just ask for that help. That's gonna be the main thing, is that you don't try to go do it on your own and then get frustrated because it doesn't work and then not do it. Okay, probation is gonna be there to help you get that taken care of. You understand?
And then I still gotta go inmate tomorrow.
Yes, for sure. Yeah, that'll be part of your probation as well, so that you get any help you need so you can be successful, get on the right path and take care of everything.
Yes.
Okay? And you're a US citizen, correct?
Yes, ma'am.
Okay. State tenders number 1 in that case.
No objection?
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
Is there, I don't typically waive a pre-sentence report on a third, but because he's already on and we're going to continue him, is there any reason not to go ahead and waive that so we can get him started?
I don't see one. no.
Any other additional information?
No, we have a lot of information already.
Okay, so in that case, which is 26-1254, I'm going to find that you just entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of failure to comply with sex offender registration requirements. sentence you in accordance with that agreement to a term of 4 years in prison, but I'm going to probate that. So you'll be on probation for 4 years. There's not going to be a new fine in that case, but you are required to follow all of the rules and conditions of probation. Again, including getting that ID taken care of, making sure you follow through with any mental health care, community service, everything else you're supposed to do while you're on probation, okay?
Would it be the same,
Yes. Yes, it will.
The same,
community service,
you're probably going to have a little bit more because of the new case, but probation will explain all that to you as well, okay? Now, the next case we have is cause number 23-41505. Let me find it. And it's my understanding in that case that the recommendation, you're on probation, is just to continue on probation. Is that correct?
That's correct, Your Honor. There's only one allegation on that motion and that's the charge you just pled to.
So let me go through the motion then. So in cause number 23-41505, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 27th of 2023, and that was a 10-year deferred probation. Is that correct?
yes,
It alleges that you violated your probation by failing to comply with the sex offender registration requirements that we just talked about. And is that true or not true?
sure,
All right, and did you enter that plea of true to count one freely and voluntarily?
yes,
And because it's actually true.
yes,
I also have documents here on the tablet in that case that you've signed with Mr. Parker. Did you also go over those with him?
yes,
And do you understand them as well?
yes,
State tenders number one,
Objection.
it's admitted. All right, Mr. Williams, I'm going to find in that case that you entered your plea of true to count one freely and voluntarily. Find count one true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. You have all the same conditions that you had, including getting that ID and getting all that taken care of. So you still now have an excellent opportunity. You're going to get out of custody. You're still on probation. You got a new probation, but I want you to understand if you don't follow through and get that ID taken care of and get registered the correct way, and you're back in here on another motion to revoke, I will have no choice but to probably send you to prison. You understand? So it's super important that you ask whatever questions you need of probation, ask Mr. Parker. They'll get you taken care of and help you, but ultimately you have to go get all that taken care of.
yes,
Okay, I'm going to hand you, did the second one print?
First.
I'm going to hand you in each of your cases, the trial court certifications that shows that these were agreements that I followed. So you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. So you're going to get out today. And very important that the first thing you do is go talk to your probation officer. Okay, go straight there when you get out. Okay, good luck to you. You can go back with a bailiff.
one thing,
Yeah,
I'm not gonna, try to do nothing to make it my matter worse and
good.
stuff, because I ain't gonna lie to you, I got two daughters,
Well, so it's time to take care of them, which means taking care of your business.
Yes.
So get out there, take care of your business, do everything you're supposed to, and you shouldn't have any other problems. But that's going to be up to you.
Yes.
Okay? All right, you go back with the bailiff. Marvin Watts, Mr. Parker, to sentencing.
Which case?
No.
I didn't even.
Is he coming down? This is an agreed that I think should be.
Yeah, that's child dental.
Mr. Cazada was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I received that pre-sentence report. Have you both had an opportunity to review the report?
You have your own.
Yes, Judge.
In addition to that, I received an amendment or a memorandum from probation with regard to some information received from the complainant in the case, including a video that was sent to me. Did you all
I
get
got
that
it.
as well?
I got you.
Okay, so for the record, I've reviewed that as well. Any additions, corrections, or objections to the pre-sentence report?
No, you're not from the state. Excuse me.
So, Mr. Quezada, this gives me a whole lot of concern. I saw the video of what happened that night, and it was very scary what you did to her and what you put her through that night. And so I know there's reasons for this plea agreement, and I'm not saying I'm not going to go along with it, in my opinion, based on the fact that there's been a prior family assault. I'm not going to agree to a 5-year deferred. There's going to be more than 5 years involved in this. And I'm considering cognitive ISF as well. I mean, this was any input?
Your Honor, I would ask that he not do ISF. He just recently got a job. He's supporting family, and I mean, they've been calling me just out of concern of that. He's their livelihood, and I understand the court's concern, but I mean, I agree that we put him on. You can put him on more probation. That's court can do that at their own discretion, and if there's any incident, then which I don't think there will be, but
What's the current stat? You're not married
No,
to her, are you?
no,
There's no relationship anymore, correct?
he's from the valley, and that's and he's living here now.
yeah, I have no communication with him.
Mr. Smith?
I don't believe there's any communication between the two at this point, Judge.
All right, so what I'm going to do is I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney. But I'm going to defer all proceedings for 8 years instead of 5 years. I'm going to order the $500 fine. Obviously, all the conditions of probation, including having absolutely no contact and no communication in any way with Veronica Panilla. I'm also going to order, at least for some amount of time, that you will be required to wear a GPS monitoring device. You'll have to have that on before you leave jail. They'll tell you how to get that taken care of. That at least gives me and everyone a little bit of, I don't know, comfort in knowing where you are at all times. If you're somewhere that you are not supposed to be, Mr. Smith will get me her information, where she works, where she lives, and all of that. The company will have that. Probation will have that information. If you get anywhere near that, there will be an immediate warrant for your arrest. You're going to be back in custody, and you're going to be looking at being found guilty and going to prison for up to 20 years. Do you understand how serious it is? If you do everything you're supposed to on this probation, this is a great opportunity. Because you don't have the conviction, you're gonna be able to keep your job, do everything, live right. Obviously, part of your probation is also going to be that you are not allowed to become intoxicated, alcohol or otherwise. I have a feeling that was involved, and so that is definitely something that is going to be very important. You cannot drink an ounce of alcohol, and you shouldn't have any issues. The other side to not doing everything right on your probation is, again, if you violate any condition at all, you'll be back in court, you'll be found guilty, which means you'll have the felony conviction, and you can go to prison anywhere in that range of punishment, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am. I got hired at the night shift, so I'll be.
So you'll have a curfew, but just talk to probation about that as soon as you get out. Get them proof of where you work and what your shift hours are. I'm not going to prevent you from working if it's a night shift, but you have to make sure they have that information. And if you're out during those curfew hours, it is only to go straight to work and straight back home. Okay?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Thank you.
Mr. Lewis, you've got Jordan Thomas.
Jordan Thomas.
Morning. Good morning. Are you Jordan Thomas?
Yes, ma'am.
And Mr. Thomas, in clause number 24, DCCR 0487, you're charged with the second-degree felony offense of sexual assault of a child from September 1st of 2023. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in clause number 24, DCCR 2178, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from August 18th of 2024. And that means the same thing. If you're found guilty in that case, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand that as
Yes.
well? In both of those cases, I have here on the tablet some plea bargain rejections that you've signed with Mr. Lewis. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plea. Do you understand all that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Thomas, Mr. Lewis has been appointed to represent you. Are you hired?
Hired.
Okay, perfect. Then Mr. Lewis will be in preparation for trial and we'll get you set on the next trial docket.
Yes, ma'am.
Thank you. Sorry, Mr. Lewis.
No problem.
And Judge, I have Ms. Burge here to translate for me.
Perfect. On wanna tell us? Thank you for letting me know that. Is there paperwork on that one?
No.
Okay, we're just go.
Yeah, we have an ice issue.
Okay.
You went in the back.
Did she? Oh, yeah.
You can come off. Good morning, Ms. Burge.
Good morning,
If you'll
Judge.
please raise your right hand. Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. Ma'am, are you want to tell us?
Yes.
And this is 26 DCCR 1248. Ms. Tellez is charged with injury to a child from March 11th of 2026. And what is the announcement?
Judge, on this situation, we do have a immigration issue and also a concern of the children are staying with a not relative, but friend of my client. And of course, with the ICE issues, we don't know how exactly that's gonna play out. So we're trying to get a little more intel on that matter.
Okay. Any issue with the reset? So, Ms. Tellez, I'm going to reset your case to give Mr. Lewis some time to do a little more research with regard to the immigration issues. And then we'll see if we can get an announcement at the next court date. You can go back with the bailiff. Thank you, Ms. Bursch.
Thank you, Judge.
Thanks.
Jean Thayer.
Hold on that for 1 second.
Sure.
Send a message to the probation department.
Yes, ma'am.
Yo, this will fail. It's like a sentencing, but we worked out an agreement, so I don't know if the paperwork is. Yeah.
Step today. You hear from Mr. Galmore on Kendrick Walker? Good morning.
Morning, Beth. How are you?
Good. How are you?
Walker.
I'm doing great today.
Are you one that figured it out?
I don't think she said her one, she's like, hours for Lotso. Look at. Good morning.
Good morning. Where's she looking?
Don't know.
Right, sir, are you Kendrick Jamal Walker?
Yes, ma'am.
And this is 24 DCCR 0196. Mr. Walker is currently on probation for unlawful possession of a firearm by a felon and a motion to revoke that community supervision has been filed. It looks like he was placed on probation August 18th of 2025, and that was a 10-year term in prison that was probated for 5 years. The allegations looks like there's an allegation of a new offense of promotion of prostitution in Harris County from May 7th of 2026, failing to report by mail or online, failing to immediately report that arrest, failing to provide verification of performing community service, failing to submit to an alcohol or drug screening back in November of 2025, failed to remain in the state of Texas, and that he was in Arizona, traveling through Arizona and Las Vegas, and that he's behind his court assessed fees. Mr. Galmore has filed a motion asking that I set a bond. There's currently no bond. Is that correct in this case? Mr. Smith, what is the state's position with regard to bond?
The state's opposed to a bond in this case, Judge. It's a straight probation. It's not a deferred. He's not entitled to a bond. The fact that he's participating in promotion of prostitution through multiple states, not completely complying with the terms, not reporting the arrest, all show a lack of respect for the court and for the terms of probation.
I am taking judicial notice of the court's file. It does include in the administrative hearing that was received from probation, the offense information from the Houston Police Department. Give me just a second to just take a quick look at this. All right, you may go ahead.
Your Honor, can I go ahead and call Mr. Walker just for the limited purpose? of
Yes, sir.
addressing
Yes,
him?
ma'am. If you'll please raise your right hand the best you can, sir. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead, ma'am.
Go ahead and state your full name just one more time for me.
Kendrick Jamal Walker,
And Mr. Walker, where do you reside?
in Cypress, Texas.
Is that in Harris County?
Yes, ma'am.
Do you pay a mortgage there?
Yes, ma'am.
And who lives there at that residence with you?
Kennedy Wilson and, I have three kids.
What's their relation to you?
Uh,
Ms. Wilson.
my wife.
Okay. Do you have a vehicle?
Yes, ma'am.
Is that a reliable vehicle that would allow you to get to and from?
Yes, ma'am.
Do you have a bank account?
Yes, ma'am.
Approximately how much is in that bank account?
46,000.
46,000.
I believe.
Just correct, 4,600. All right. Do you currently have a job?
Yes, ma'am.
Are they aware of what's going on right now?
Yes, ma'am.
Did you notify them?
Yes, ma'am.
Do you still have that job currently if you were to be released on bond?
Yes, ma'am.
Where's that job located?
In Cypress, Texas.
Cypress, Texas, again, that's in Harris County.
Yes, ma'am.
Are you attending any colleges?
Yes, ma'am.
And where's that college located?
In Cypress.
Cypress, so again, Harris County.
Yes, ma'am. Long Star.
Do you have family here in the Beaumont area?
Yes, ma'am.
And you're able to frequently visit with them?
Yes, ma'am.
A strong support system with your family?
Yes, ma'am.
Just briefly, when you were arrested on the case before the court today, did you report that to your Harris County probation officer?
Yes, ma'am. You did.
Okay, and whenever she told you, or whenever you reported to her, what did she inform you?
That she advised me that Jefferson County would most likely put out a motion to revoke my probation.
And is that what happened?
Yes, ma'am.
And you knew that was happened when you reported at the next instance, correct?
Yes, ma'am.
So you had every intention of dealing with this head on?
Yes, ma'am.
No intention of running away from the situation?
No, ma'am.
Nothing further, Your Honor.
Any questions,
No
Mr. Smith?
questions.
All right, any other witnesses?
No, Your Honor.
I'm still going through a little bit. Give me just a second.
Yes, Judge.
So you say you're married to who?
Kennedy Woods, Walker.
Okay. But at the time of this new arrest, you said that you had this new girlfriend for 3 weeks.
This is a friend, and this is not a girl, like a friend of just.
Just a friend that's a girl.
This was an that she told me.
Okay. Nothing. Like the underlying offense. Other than that possession of a controlled substance from 2019, Mr. Smith, is there anything else that you have?
From history and with MTLP funds, Judge.
Okay.
All I have is the PSI that underlying.
The indictment didn't allege anything else other than the possession from 2019. I was just trying to. All right, so what I'm going to do at this time, I am going to grant the motion. I'm going to set bond in Mr. Walker's case at $150,000. Condition of that bond, if it's made, is that Mr. Walker would be required to remain in Jefferson County, Texas without permission. I would need more information on job, location, things like that before I allowed him to leave. There would be a GPS monitoring device and all of the other standard conditions of probation, and then we will reset the case for an announcement.
Yes,
All right,
Judge.
can go back with the bailiff.
May I be excused? Judge?
Yes, ma'am, thank you. Okay, that's okay. I wrote it on here, so I didn't forget. I did. Who? Okay. Mr. Lewis, Christopher Fair. That's a sentencing.
And Judge, this one we have an agreement on.
Okay.
Yes, we do that.
Good morning. Are you Christopher Fair?
Yes, sir.
And so this is cause number 18-30684. Mr. Fair was previously in court on a first amended motion to revoke unadjudicated probation and entered pleas of true to counts 1 through 6 and 9 through 12. There was no agreement at that time. I ordered an updated pre-sentence report. I've received that report. So let's start there. Have you both had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections to the report?
No.
Not from the state.
So it's my understanding, though, at this time, you guys have come up with an agreement on sentencing, however, instead of just leaving it up to the court. Is that correct?
That's
I don't need to go through any of the other allegations since he's pled to most of them.
No, Your Honor.
Okay. So, Mr. Fair, I have now in your case on the tablet some documents that have your signature on them that the state's marked as exhibit number 1 that you signed with Mr. Lewis. Did you go over those with him and do you fully understand them?
Yeah.
And I want to make sure you understand if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal.
Yes, sir.
State tenders number 1.
Yes, Your Honor.
No, Judge.
It's admitted. There's no evidence Mr. Fair's not competent. Well, Mr. Fair, you probably made a good deal today because I had some pretty bad notes on your PSI. I'm going to find that you previously entered your pleas of true to counts 1 through 6 and 9 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of indecency with a child. Sentence you in accordance with your agreement to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis.
Your Honor.
Yes, ma'am.
It's also to receive the sex offender registration now that there's an adjudication of guilt.
Probably should have been done at the original plea.
It may have. I wasn't here at that
Hold on,
time.
I
I
can
just
look.
want to make sure
Yes,
the record is
ma'am.
clear.
I do want to make you also understand that you will be required to register as a sex offender as part of that was done back in 2019.
Okay,
He's been
good.
required to do that. Okay, all right, you can go back with the bailiff.
Thanks, Judge.
Hey.
Nope, that's good. Judge Troya Green. Ms. Malfino, are you ready on the Mr. Watts? Okay, I'll get to it in just a second.
Okay. One of those little Jesper hats on.
You do need you're wearing lots of hats.
I have a short hearing on couch as well.
Okay. Good morning. Are you Judge Troya Green? And this is cause number 26 DCCR 1065. Ms. Green is charged with a first degree felony offense of aggravated assault with a motor vehicle, discharging a gun out of a motor vehicle. Is that correct? From May 16th of 2026. And what is the announcement?
Judge, I've gotten discovery and I've gotten an offer from Mr. Nichols. I have a counter offer that I've talked to Ms. Mofino shortly about this morning. I want to talk to Mr. Nichols about when he gets back. That's
Okay.
possible resolve this issue.
Okay, I'll just do one normal reset to give you time to get that taken care of. I'm sure Mr. Lewis will be out to see you as soon as he visits with Mr. Nichols, let you know all your options, and we'll get an announcement at the next court date. All right, you can go back with the bailiff.
It just changes it from straight to a cat to.
Okay.
her family.
Okay, thank you, ma'am. Well. I think Mr. Lewis only has, what were we doing on Gene Thayer? You're ready on that? Let's do that one real quick, and that way Mr. Lewis is done. Gene Thayer, and then we'll take care of,
This is an old case, Judge, that has been told for several years by that motion. If it looks a little odd.
oh, okay, so the motion to revoke was filed back in 23,
23.
and he's been at large. Good morning. Are you Gene Thayer Jr.?
Yes, ma'am.
This is clause number 18-28661. Mr. Thayer is on probation for the state jail felony offense of credit or debit card abuse. Looks like put on that probation back in May of 2019. It was a 3-year deferred probation. A motion to revoke that probation was filed in January of 2023 with the allegations that he failed to report to the Liberty County Probation Department in 2022, failed to report by mail to the Jefferson County Probation Department, behind in court assessed fees, did not provide documentation within 30 days regarding a budget sheet and things like that. The motion was filed, and then it looks like Mr. Thayer has been at large since then, and then arrested July of this year on the motion that's been pending since January 5th of 2023. Mr. Lewis has filed a motion asking that I set a bond in this case. Mr. Lewis, you may proceed.
Judge, this is a situation, like I said, it's definitely one that had been filed a long time ago. It looks like a situation where he had completed all of his conditions that he had, but he still had other obligations like the financial side and things of that nature. He was having some financial hardships. He has started working recently. Matter of fact, when he was arrested on this motion, he was driving his 18-wheeler and pulled over and was taken into custody on a job. So financially, he's back in a better position now where he can take care of those obligations, and including being able to
Well, let me stop you, because part of the problem, I think, because of the age of it, it's over 5 years. He cannot be continued on probation ultimately in this case.
Oh, yeah, I understand.
So it either has to be a revocation or a revocation with a straight probation, because the amount of time that's passed, am I correct, from 2019 to?
Well, and to go to that issue, Judge, what I've talked about with Ms. Mofino is that there are some issues that we definitely need to follow up on with the checking in, because according to my client, a lot of that was done. May have been, I think the mailing in problem is more the problem than the in-person for the longest time. And so because of that, I think if we can verify some of that, that'll be easier for us to make a decision if we're gonna be able to try to move this to a straight probation, or if there's something that he can actually move forward on. But my concern right now is him for his being in custody, see if we can get him out on bond. He's more than willing to comply with any GPS monitoring or anything like that what would require of him.
Where do you live, Mr. Thayer?
In Coons,
Address?
12715, Highway 326 North.
Ms. Malfino, what's the state's position?
Judge, I have spoken with Miss Martinez, his officer this morning. With respect to some mitigating factors, I think that is what Mr. Lewis is leaning towards, that he may have been reporting elsewhere in person, but failing to do so by mail. So it looks more like his absconding than it actually was. I don't know that for sure. That's why at this time, based on it just looking like on paper, he's an absconder, I would object to a bond, Judge, because we finally now have him before you after this many years. The state can be prepared for a hearing on the motion. I mean, I can be prepared for hearing on motion 11 o'clock if you need me to be. But if we made a state jail offer in the alternative, I think the mitigation was what they wanted to provide for the court to lend towards that straight probation in lieu of the revocation.
I'm gonna do this. I'm gonna grant the motion to set a bond. It is a deferred probation. It's a state jail. I'm gonna set the bond in this case at $30,000. Condition of that bond is Mr. Thayer, that you are required to remain in either Hardin or Jefferson County. You must reside at the residence that you told me, 12715 Highway 326 North. You will be required to wear a GPS monitoring device. You will have to have that put on before you leave the Jefferson County Jail. As soon as you get out, if you make that bond, talk to Mr. Lewis, talk to your probation officer, and then we'll set your case for an announcement. All right, you can go back with the bailiff.
Thank you.
Thank you.
Oh, gosh. All right, Marvin Watts. Marvin, what? I want my voice back. I want my voice back. I promise I have not picked up smoking cigars. At least sound nice.
Snow.
That's
Good morning, sir. You're Marvin Watts.
Yes, ma'am.
And Mr. Watts is here in cause number 25 DCCR 1918 and 26 DCCR 0946. Each of those cases previously in court entered pleas of guilty, and each of them to the first-degree felony offenses of aggravated robbery. The agreements were per cap of 17 years in the institutional division on each of those. I've received the pre-sentence report. Have you both had an opportunity to review the report?
we have, Your Honor.
I have, Judge.
Any additions or corrections?
I'm aware of, Judge.
Yes, Judge, the state would like to call Detective Josh Jackson, please.
Detective Jackson? You'll just kind of slide over a little bit, sir. Right there's fine. Good morning, sir. Sorry I had to wait a little bit. If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Ms. Malfino?
Thank you, Judge. As the court has already done, would you please take judicial notice of the PSI? I say that specifically towards Detective Jackson's detailed statement therein. And I would just add a little bit of subsequent testimony to that.
Sure.
Would you please state your name for the record?
Joshua Jackson,
And how are you employed?
a detective with Beaumont Police Department.
And as a detective with BPD, is it your duty to investigate violent crimes such as homicide, aggravated robbery, et cetera?
It is.
And did you have a chance to investigate an aggravated robbery that occurred in October of 2025 at the Dollar General on Highland?
Yes.
And did you later learn that that aggravated robbery went hand in hand, for lack of a better term, with an aggravated robbery that had occurred at Dollar General in September, the Express Mart in October?
That's correct.
So within a 1 month time period, there had been 2 aggravated robberies of stores located here in Beaumont relatively close together.
That's correct.
All this occurred in Jefferson County.
Yes.
And can you describe for the court, you have elaborated in the pre-sentence investigation report, your thoughts a little bit, and obviously the court is aware of the nature of the offense, et cetera. A little bit more about your thoughts for the sentencing hearing before we get to the video.
So, both of these cases involve, 2 guys that go into a store, one, during daylight hours, another one during nighttime hours. Both victimizing a clerk that's there just trying to do her job. There's no glass barrier on either of these stores. These 2 guys walk in there, hold the clerk up in each of these instances and proceed to rob the clerk for, at least in mine, money and some cigarettes. And for this to happen in daylight hours or nighttime hours to somebody that's just trying to go to work, isn't right. I mean, you don't go to work expecting to get robbed when you potentially have family at home, and during either of these robberies, something tragic could have happened.
And Detective Jackson, I think it goes without saying, from both the perspective of the state and the court, but from your perspective as a detective, is violent crime involving firearms and youthful offenders here in Beaumont something that has just become extremely prevalent, unfortunately.
Absolutely.
And is it something that you continue to investigate on a daily basis?
That's correct.
Do you think it would be helpful for the court to view, if you would, Judge, outside of the cameras due to the sensitive nature of the complainant in the case and her identity, the video from the incident in September at the Dollar General?
Yeah, so there's 2 videos with just the Dollar General on this one that I brought with different angles. It's just giving you an idea of kind of what happened to at least the Dollar General one. There's a lot that it's not going to show, which is the aftermath of it and speaking to the clerk and the terror and how she felt. Of course, that's all in the whole case, but at least these 2 videos.
And it's the same, just 2 different views.
Yes, ma'am.
Okay.
May I continue?
Yes, ma'am.
Detective Jackson, obviously the court has taken note of your statement in the PSI, but is there anything additional that you would like to add for the record with respect to the sentencing you would like to see the court impose?
No, I think what I wanted to convey is mainly in that email that I sent.
Thank you. I have no further questions.
Thank you. Any questions?
No questions.
Thank you very much for being here, Detective. I appreciate you. Any other witnesses?
No, Judge, just a couple comments if I may.
Sure, go ahead.
Obviously, it asked the court to take everything into account, the fact that there are 2 aggravating offenses. Obviously, you are aware of the prevalence of these type of offenses in Beaumont involving young offender with firearms, innocent victims in this type of a case. Officer Riley's comments, I think, are also important, Judge. He's a very detailed PSI writer, and his caution against leniency the state would concur with. In addition to the jail incidents, which show the court, as you're aware, that Mr. Watts cannot behave while in custody, so therefore what leads us to believe that he would behave while on probation. Based on those, Judge, I would concur with the offer of Mr. Nichols at 17 years and ask the court for 17 years in each case.
Thank you, Ms. Malfino. Mr. Parker, you may proceed.
Your Honor, in regard to the write-ups, I've talked to him about those. Those happened prior to the his PSI, and that was when he was in maximum security. And from what I understand, it's a lot harder to not get in trouble there because of who you're around. But nevertheless, he has no juvenile record that I'm aware of. He has no adult history that I'm aware of. These are the only 2 cases that he's ever had any issues with. I agree, they're serious offenses. He understands that. he's told me today that, you know, if I could apologize to people, I would. He was encouraged by somebody older than him. I believe it was probably his father, so it was. And he's asking the court to give him probation. He would like to address the court, Judge.
Go ahead.
No, I apologize for my actions, ma'am. Honestly, I regret them. I really do, ma'am. Like my attorney said, if I had a chance to apologize to that woman, I would. And ma'am, those write-ups were while I was in maximum security, ma'am. I was not supposed to be in max. I was there because my shoulder popped out of place. And all of those offenses were like, really, some of them, like, certain ones I do not understand how they were just.
I'm a whole lot less worried about that than what you were doing when you were
Yeah,
out.
but honestly, on that calm, I do apologize to that woman and for everything that I've done, man. I regret it very much. It's not just right there, really. Like, you sit on my mind daily, man, honestly. And I really feel like whatever I did is my sin into account.
I appreciate you saying that. I hope that you're sincere. No matter what happens today, you have an ability at your age to change your life and do better things. Unfortunately, I tend to believe that sometimes people are sorry because they got caught, not because really of what they did. I don't disagree with Mr. Parker that looks like your dad's the one that's encouraging you to go out and do this crap. But all that being said, 2 times within a month, hoodies, mask, gloves, a pistol, another gun that has some kind of, I don't even know what it's called.
Silencer.
No, it was the circle thing that has a bunch of,
Your magazine.
thank you, drum magazine.
Honestly, I don't know nothing about it. Like, I mean, like you said, I'm be honest with you, man. It was my fault. Like, but I did not have no intentions on doing no crime before my father showed up, man. Honestly, I didn't know nothing about how to rob a store, to do nothing with the store, I didn't see those stuff. So, like,
Well, you went all in, didn't you?
I did.
And Tara, I mean, y'all didn't just walk in and take it. You got to grab her. You got to pull her around. You got to show that you're a man. Somebody did. While the other, so that means you were the one holding the gun with the drum, because the one that had the pistol is the one that was pulling her around. Okay. At this time, I'm going to, Mr. Watts, find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 25, DCCR 1918, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 17 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case, and you will receive credit on it for any time that you've been in custody that the law gives you the right to receive. In clause number 26, DCCR 0946, also find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 17 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case as well. These cases will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certification that shows these were agreements that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Again, you're young. You're going to go to prison, obviously, for some amount of time. It's going to be up to you to do something different or not when you get out. All right. You can go back with the bailiff. Thank you. Thank you, Detective Jackson, for doing that.
Thanks.
Mr. Rojas, you've got Jaden Brantley.
Brantley, not inclined to, but if you get what I want to, yeah.
Good morning. Thanks for being patient.
Sure.
Not that you have a choice.
My suggestion would be 1 week you do the ABC and the next week do ZBA.
I've tried to do some backwards, every now and then. I don't know if you've noticed, but I have. This is, Mr. Nichols' case on a Jaden Brantley. Good morning, you're Jaden Brantley. And this is cause number 26, DCCR 0422. Mr. Brantley's charged with a first-degree felony offense of aggravated robbery from February 6th of 2026. And what that means, Mr. Brantley, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison, which means you would be leaving your punishment up to me. And as long as I didn't give you more than 25 years, I could give you 25 years, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have your case set for trial. Let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. You understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
All right, we'll get it set for trial. Is there any reason, I know that is Mr. Nichols' case, but is there any reason to believe, is there anything outstanding or why that offer would change?
Looks like the media has been picked up, Judge, as per the offer, nothing to my knowledge.
So I do want to make sure you understand, Mr. Brantley, once I place your case on the trial docket, then it's expected to go to trial. If you change your mind later and want to enter a plea of guilty, it would be to something different than this. Do you understand?
Yes.
All right, and so Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you're released. Mr. Brantley, I'll appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Thank you. Jimmy Couch, the Senate.
Jimmy Couch.
Mm-mm.
Morning, Your Honor.
Good morning, you're Jimmy Couch.
Yes, ma'am.
And this is cause number 26, DCCR 0328. Mr. Couch was previously in court, entered a plea of guilty to the lesser offense of a third-degree felony attempt to commit burglary of a habitation. I've received the pre-sentence report. Have you both had an opportunity to review the report?
We have, Your Honor.
I have, Judge.
Are there any additions? Excuse me, additions or corrections?
No additions or corrections, Judge, just comments whenever the judge would.
Okay. Anything, Ms. Malfino?
Judge, I would just like to clarify for the court that the offer of the attempt to commit was made based on my review of the facts. I think it was more appropriate to the facts of the case that it be an attempt. It was not an attempt, no pun intended, to lessen his culpability or anything of that nature. I just think that fit the facts better and was a more appropriate plea. Ask the court to take notice of the PSI and also for some very brief comments. If the court would find it helpful, I would like to call Mr. Couch's wife, ex-wife, Allison Couch, just to let the court know some things about how strongly she's going to ask the court for safety and the state's going to ask for safety in this case. And I think it would just help give you, if you
That's
feel like you
agreed
need it.
though, right?
Safety was not agreed, Judge.
No, ma'am.
Not agreed.
Oh, safety's happening.
Ma'am?
If I give you probation, then safety is going to be a condition of that probation. End of
Yeah, ma'am.
story. So, I mean, either here's the thing, Mr. Couch, conditions of probation
Yes,
are up to the court, 100%.
Okay.
So even if that had not been part of your agreement, it doesn't invalidate your agreement because impose any conditions that I think would be either helpful or necessary to make sure that everybody that's on a probation has the best possible chance of success and that everybody else out there is safe and secure as we can make them. And so if I follow this agreement, it is going to be with safety based on I've got the her statements, and thank you for being here, ma'am. I've got the statements she has here, and I appreciate that she's here in person as well. That means a lot. If there's something that's not in here, we'll take judicial notice of her statements as well as the probation reports statements with regard to substance abuse history and the fact that they believe that he needs substance abuse help, but he does not.
Do I get to make a statement?
Sure.
Your Honor, I don't do drugs. I haven't done drugs since I was a stupid kid, 20 years old. I don't do any drugs whatsoever.
Well, it's not just about drugs, it's about alcohol as well.
And I don't have an alcohol problem, Your Honor. I might drink a beer or two a week. That's it. I don't have any alcohol problem. I mean, I don't understand. I've already lost 6 months of my life and I have serious lung disease that I have to have another PET scan and another biopsy because the spot on my lungs is growing. I've coughed up blood 4 times in the last 3 months, been in jail. They will not give me my medications or my lung
Well,
treatment.
maybe you shouldn't have gone and committed this offense.
Your Honor,
Hang on, listen.
I
Okay,
apologize.
just hang on. I understand some medical issues.
Mhm.
But that's not what's going to go into completely any decision that I make. Okay, so just hang on a second.
Okay.
Mr. Rojas,
Judge, I would just point out that at least from his, whatever he self-reported to the probation department, looks like the last time he used any drugs was 2023, and that he tells me that was prescribed from a surgery he had.
Yeah, that's my surgery.
And the last time he used alcohol was August of 2025, and he was out on bond until June of this year. So if that's true, it would tend to show that he didn't have an alcohol problem.
if your witness is willing to come testify under oath, then that would be probably good.
Thank you, Judge. Ms. Couch. Maiden name, Byron.
Okay. Go on.
Don't interrupt.
Okay.
Good morning, ma'am.
Good morning.
If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Ms. Malfino.
Ms. Couch, would you please state your full legal name for the record, please?
Allison Couch.
And how do you know the defendant, Jimmy Couch?
He's my ex-husband.
Okay. Can you tell the court, obviously you are aware that we're here for a sentencing hearing today, correct? And is it correct that you and I have kept in pretty constant communication with respect to this offense? And you filled me in on a lot about the defendant, his history, his substance abuse history that may not be included just with respect to this offense, correct?
That's correct.
And do you think it would be helpful to Judge West to hear just a very little bit about that, especially after you've seen how the defendant has acted this morning, which was obviously a concern of all of ours, correct? That he continues to minimize, he distances himself from the severity of his alcoholism or substance abuse problem. Would you think?
He's mouthing something.
Look at me. You turn to actually do this. Turn around and look at that wall. Go ahead, ma'am.
I'm sorry, Judge. Do you think it would be helpful for the court, from your perspective, to know just a little bit more about Mr. Couch and what you want for him with respect to his trying to get help and why you and I discussed at length this offer and a chance at probation to try to get him the substance abuse help?
The whole point in this and me sticking this through is to get him the help he needs. He's a serious, serious alcoholic. His family knows it. His friends know it. I lived with it. It's terrible. And we love him, but we want him to get well. He hasn't been able to do it on his own. And this is our last resort, is basically what this is.
It's either this or prison, right?
Yes.
And
Or he'll kill somebody while he's out there driving drunk.
And do you believe this with everything you know about the defendant?
Everything. I've experienced a lot with Jimmy. It's been a very hard experience. But I do have a lot of love and heart and care for him in my heart to see him through this. I want to see him get help.
And is that in fact why you are asking the court to consider allowing him to serve this probation, but imposing safety, which we have discussed is the most stringent lockdown treatment program with all of the aftercare conditions, et cetera, with a condition that afterwards he have no contact with you. I know we had discussed some things with concern to his sister's concerned she may come there, you're concerned he may come to you. And he's got to learn how to stand on his own 2 feet and not bring his problems back into everyone else's life. You're asking Judge to do that.
Well, we do know that he has nowhere to live. He has nowhere to go. He has no, I mean, the family knows what's going on. Nobody can take him at this point. But we don't want to see him not have communication with family. We feel like that's part of the healing that he's going to go through. But we do feel that he's going to have to be forced to do this because he has failed on his own prior to this. He didn't complete a rehab he did before. And it's just it hasn't stopped.
Thank you. Any questions, Mr. Rojas?
Sorry.
When was that rehab?
It was 2 years ago.
And you guys were still married at that time?
Yes.
And when's the last time you actually saw him take a drink?
Right before, he was drunk when he came to my house and got arrested. Yeah, he's been drinking up until he got arrested.
And that was in January.
Yes.
Pass the witness, Judge.
All right. Thank you very much, ma'am.
Can I turn that?
I'm standing right here.
I'll get-
Any other witnesses?
No.
All right.
Can I call my witness?
No, you have an attorney. Mr. Couch, what you're doing today is giving me more and more concern about whether or not I should even follow this agreement. You are interrupting, you are denying everything. In fact, I already had a mark in this pre-sentence report that you pretty much your version of the offense is not what the official version is, and it's not accepting responsibility. Flat out not accepting responsibility. So if I'm going to go along with this agreement, it is going to be with help, whether you think you need it or not. So at this time, in cause number 26, DCCR 0328, going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the safety program. You have, it sounds like, people who love you and care about you and want you to do better. It's going to be up to you to do that. Part of your probation is going to be to have no in-person contact with Allison Couch. If there is at the time through probation that communication is helpful.
In this courtroom, what started as a routine status conference quickly turned into a surprisingly positive moment. First, Keith Johnson appeared before the court after his attorney confirmed that they had reviewed the discovery and received an offer from the state. According to the proposed resolution, Johnson would need to complete an alcohol course and write an apology letter. If he completed those requirements, the case could be resolved with a misdemeanor outcome and costs only. The judge gave Johnson time to complete the courses and scheduled a tentative plea and sentencing date, making it clear that the next step was entirely in his hands. But the more memorable moment came later when Lee Rogers appeared by video for his own status conference. Before the hearing even began, the judge gave Rogers a lighthearted lesson on how to mute and unmute himself on Zoom. After a few attempts, Rogers finally figured it out, earning a cheerful, "You did it all by yourself. Good job." Once his attorney arrived, the conversation turned serious. Rogers' lawyer explained that they still needed time to review discovery and gather information from Minnesota, especially after Rogers had recently completed a treatment program. Then Rogers shared something that completely changed the tone of the hearing. He told the judge that he had been sober for 60 days, the longest period of sobriety in his